What's up, guys? Igor Hernandez here. Let's talk trial. Today we're going to talk about the impeachment of the forgetful witness. And what I mean by that is, every now and then you're trying a case and there's a witness who would have had some damaging testimony, and the witness comes in and gives the damaging testimony at trial, but the witness is given a deposition where he or she has testified very differently about that portion of the testimony. So let's say, for argument's sake, in a personal injury action, a witness who saw the accident says the other side took the red light and your client had the green light, so therefore it's the other side's fault that the accident happened. They testify to that in the deposition. They come in at trial and testify that, the client actually, your client actually had the red light, and so your client took the red light, and so it is your client's fault, right? And so you're thinking, well, that's interesting because that's the complete opposite of what he or she said at deposition, and so you get up there on impeachment, right? And so you're like, oh, this is not the first time you testified in this case, you testified in the deposition, blah, 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 page and line. And when you hit him with the page and line, the witness says, oh, I do not remember saying that in my deposition. So basically you ask him, in that deposition you testify to question, did my client have the green light? And your answer, yes. And he'll say, no, I don't know what you're talking about, man. I don't remember, saying that in the deposition. And then you're like, okay, does, looking at the transcript refresh your memory? Or if you want to do it on as a leading question, well, looking at the transcript will refresh your memory, right, witness? And the witness say, no, I don't think so, man. So basically, at this point, at least in the jurisdictions that I've practiced, you're kind of stuck on that end of refreshing, because if the witness does not say that looking at the particular document or thing is going to help him or her remember, you can't really go up there and show it to him. So now you're thinking, damn, he says he does not remember testifying about it in deposition. He says looking at the transcript will not help him remember. And so what do I do next? Now, mind you, at this point you may be thinking, well, I have a legitimate argument in closing that he, looking at his own testimony that he gave 6 months ago, he's saying that's not going to help him remember, right? But we don't want to stop there, and that's where a lot of lawyers stop, because, you get caught up in this kind of messy situation and you're not really sure how to handle it. And I'll be honest, it's happened to me. It's happened to me in a big case. I handled it pretty good. I didn't handle it appropriately, and it certainly, some of what I did was not legal. And so after that, I hit the books and had to really give a lot of thought as to how you handle this appropriately, at least in the jurisdictions that I've practiced. And here's what you do, right? Well, number one, in a lot of jurisdictions, when the witness is impeached with a prior inconsistent statement, when the witness basically, you ask him, look, in deposition you testify to why, if the witness does not distinctly admit making that statement, you're not in refreshing territory. You're not in the witness forgot, I need to refresh territory. You are in impeachment territory, which means you can introduce what we call the extrinsic evidence of the impeachment as substantive evidence for the jury. Basically, the witness says, look, I don't know what you're talking about. I don't remember saying that in the deposition. You can lay the foundation for that portion of the deposition as to, you would agree with me, you testified in the deposition on such and such date. We talked about this accident, blah, blah, you were there, I was there, blah, blah. And introduce, actually bringing into evidence that portion of the testimony, even if the witness says, I don't remember saying that. So you put before the jury the transcript or the portion of the transcript where the witness is giving that testimony. Okay, that's one way to do it. Obviously, if the deposition was video recorded, even better. You lay the foundation for the actual tape, and you could introduce that portion of the tape where the witness is saying the inconsistent statement, even though the witness is saying, I don't remember saying that at the deposition. Now, mind you, this is very different from the witness not remembering a fact. So, if the witness comes in and says, he takes a stand and you ask him, who had the red light or whatever, let's say it's direct examination or cross-examination, my client had the green light, and the witness says, I do not remember who had the green light and who had the red light. I do not remember basically the fact, not the inconsistent statement, but I don't remember the fact, right? In that scenario, you are certainly in refreshing memory territory. So what I just said doesn't really apply here, with one exception, and at least in the jurisdictions where I practice, and it probably is different for you, or it may be different for you. In the jurisdictions where I practice, if the testimony would be about a matter that is such that it naturally would be a thing that the witness would remember. Basically, the kind of thing that you're thinking, yeah, right, there's no way that you forgot this, then you may impeach as if the witness had given a prior inconsistent statement, or rather as if the witness on the stand had given an inconsistent statement. But for 90% of the things that witnesses will testify to, it's going to be hard to get the judge on board with that, and so you will need to go into refreshing recollection territory, I guess. Now, I said introducing the statement as a prior inconsistent statement because the witness is not distinctly admitted to making the statement is one way to handle when the witness does not remember making the prior inconsistent statement. The other way is to lay foundation for a hearsay exception. So in my jurisdiction, or the jurisdictions that I've practiced law in, there are multiple hearsay exceptions that would allow statements made out of court to be introduced into evidence. In a lot of cases, the witness will give you the foundation for what's called a prior recollection recorded. Basically, what that exception says is that if the witness gave a statement, and at the time of giving that statement, his or her memory was fresh about the events, and then now he does not remember when he's on trial or when he's testifying, he does not remember those facts, you can introduce that statement so long as obviously you lay that foundation. So let's say you say, you know, my client had the green light, he says, no, he had the red light, he's at fault. You lose type of testimony, you lay the foundation for impeachment, he says, or she says, I do not remember making that statement. You could either do what I said earlier, or you could go into introducing the prior recollection recorded. Either way would probably be fine. There's a distinction in some jurisdictions between criminal and civil depositions and whether you can do this or not. But for the most part, if it's a civil case, definitely. If it's a criminal case, maybe. You can do the following, which is the witness says, I do not remember making that statement. You go, okay, well, when you gave this deposition, you had a fresh memory about the facts of this case, right? In fact, I asked you in the beginning of the deposition if there was any reason why you would not have a good recollection as to what happened. You said there's no reason for that, and you proceeded to testify as to everything you remembered at that time. Do I have that right? And the witness will say, yeah, at that time, when I testified about the facts I remembered. So when you testified as to whether my client had the green light or the red light, those facts were fresh in your mind at that point, meaning you remembered at that time whether my client had the green light or the red light. The witness would say yes. And then you can introduce, and obviously now you're saying you don't remember, right? You got to lay that, the bottom of the last step of the foundation. And the witness will say, yeah, I don't remember. And then you can introduce that statement as a prior recollection recorded. The only reason I would not necessarily recommend this aspect of it is because the witness, if he wants to fight you, would say, well, at that point, I don't know if I remembered or not. I don't know why I was testifying. I wasn't sure what happened, all this other BS. Because a witness that comes in and does not remember saying something completely opposite of what he's testifying on the stand about is somebody who's doing that on purpose. It's not somebody who just doesn't remember. He's somebody who's out to hurt you for whatever reason. So he's not really gonna give you things other than the things he or she's got to give you. So I would not recommend the prior recollection recorded, but it's a tool in your toolbox to use. I would recommend introducing the extrinsic evidence because the witness has not distinctly admitted making that statement when confronted with it. The one kind of segue about prior recollection recorded is that could be very helpful when a witness comes in and he or she does not want to be helpful. For example, somebody who wrote a report at the time, but they don't really want to be involved with the case. So when you call them to testify, they say, I don't remember anything. You know, I do 1,000 of these and I don't remember anything that happened that day. You can lay that foundation and basically walk them through when you wrote this, your memory was fresh about the facts of the case. when you wrote this, you were writing things that you had knowledge about that was fresh in your mind, and now you do not remember about that. You don't have that memory anymore, let's say, according to the witness. And then you can introduce the actual statement as a hearsay exception of prior recollection recorded. But anyway, that may be for another video. If you like the video, go ahead and like the video. If you hit the notification bell, it's going to tell you when I have some new videos coming up, and catch you again next time.